She pushed her cleaning cart through the courtroom doors like she had every morning for the past 3 years. Gray uniform, worn sneakers, a headscarf that covered silver hair no one had ever really noticed. The lawyers barely acknowledged her presence as she emptied trash cans and dusted the witness stand. To them, she was invisible, just another courthouse employee doing a job that kept their world functioning. But when the most complex case in the county's history reached a deadlock, when seasoned attorneys sat speechless and the judge pounded his gavel shouting, "Order in this court," the cleaning lady did something no one expected. She set down her mop, stood up straight, and began speaking with the authority of someone who had spent 40 years not cleaning courtrooms, but presiding over them. Welcome to those who left a trace. Before we dive into this incredible story of hidden wisdom, respect, and the moment when true expertise revealed itself in the most unexpected way, tell me in the comments what city you're watching from today. And if you believe that knowledge and experience can't be measured by the uniform someone wears, hit that subscribe button. These stories remind us that legends often hide in plain sight. The Riverside County Superior Court had seen its share of complex cases over the years, but nothing quite like Peterson versus Morrison Industries. What started as a simple employment discrimination lawsuit had evolved into a legal maze involving federal regulations, international labor law, constitutional questions, and precedents that stretch back decades. The case had been in litigation for 18 months, consumed hundreds of thousands of dollars in legal fees, and attracted attention from law schools across the country as students tried to predict how the various legal theories would interact. Judge Harold Brennan presided over Courtroom 4 with the weary authority of someone who had been making difficult decisions for 26 years. He was known for his fairness, his patience with inexperienced attorneys, and his ability to find legal solutions when cases seemed hopelessly deadlocked. But Peterson versus Morrison was testing even his considerable experience. The legal issues were so intertwined, the precedents so contradictory, that even the most basic procedural questions seemed to require hours of research and debate. Elena Martinez had been cleaning Courtroom 4 for 3 years, arriving each morning at 6:30 a.m. to prepare the space for the day's proceedings. She worked quietly, efficiently, never interfering with the legal proceedings, but always present, moving to the courtroom with the invisible competence that kept the judicial system functioning. Lawyers and court staff had grown accustomed to her presence. The soft sound of her cleaning cart, the careful way she dusted around legal documents, the respectful distance she maintained during sensitive discussions. What none of them knew was that Elena listened, not out of curiosity or entertainment, but with the focused attention of someone who understood the intricacies of legal argument, the weight of precedent, and the careful balance between law and justice that determined the outcome of every case. She heard the attorneys struggle with concepts she had wrestled with for decades, watched them research precedents she had helped establish, and observed them make arguments that revealed fundamental misunderstandings of the legal principles at stake. On this particular morning, the courtroom was packed beyond its normal capacity. Representatives from labor unions, corporate legal departments, civil rights organizations, and academic institutions filled every available seat. The Peterson case had become a bellwether for employment law, and the outcome would influence similar cases across the country. The pressure on Judge Brennan and the attorneys was evident in their tense expressions and the careful formality of their language. Lead counsel for Peterson was Margaret Chun, a Harvard-educated attorney with 15 years of experience in employment discrimination cases. She was brilliant, thorough, and completely overwhelmed by the legal complexity of the case she was trying to argue. Across from her sat the Morrison Industries legal team, led by Richard Holbrook, whose corporate law expertise was matched only by his reputation for aggressive litigation tactics that pushed the boundaries of legal ethics. The morning session began with Judge Brennan's attempt to clarify the central legal question, but within minutes, the courtroom erupted into the kind of legal chaos that made law students question their career choices. Chun argued that federal employment regulations superseded state contract law, while Holbrook insisted that constitutional Commerce Clause limitations restricted federal jurisdiction. Both attorneys cited precedents, but their interpretation of those precedents contradicted each other so fundamentally that Judge Brennan found himself questioning his own understanding of legal principles he had applied for decades. "Your Honor," Chin said, standing to address the court, "the Morrison Industries employment contract clearly violates federal guidelines established in Rodriguez versus Universal Manufacturing, which held that." "Objection," Holbrook interrupted. "Counsel is mischaracterizing the Rodriguez decision. That case specifically excluded situations involving interstate commerce, which is exactly what we're dealing with here." "That's completely incorrect," Chin shot back. "Rodriguez versus Universal was overturned by the Fifth Circuit in Fleming versus Consolidated Services, which expanded federal jurisdiction to—" "Fleming was a tax case," Holbrook countered. "It has no bearing on employment law." Judge Brennan pounded his gavel. "Counselors, please. Let's take this one issue at a time. Ms. Chun, can you cite the specific section of the Rodriguez decision that supports your argument?" Chun rifled through her papers, her confidence wavering as she realized that her research team might have missed something crucial. "Your Honor, I have the case files here, but the specific section, I may need to request a brief recess to verify the exact language." Holbrook seized the opportunity. "Your Honor, this demonstrates the weakness of plaintiff's argument. They're citing cases they haven't properly researched, making claims they can't support with evidence." "Mr. Holbrook, your tone is inappropriate," Judge Brennan warned. "But Ms. Chun, I am concerned about the accuracy of your legal citations. This is a complex case with significant implications, and I need to be certain that all legal arguments are properly supported." From the back of the courtroom, Elena continued her quiet work, emptying trash CA and replacing water pitchers. But her attention was focused on the legal debate unfolding before her. She recognized the confusion immediately. Both attorneys were partially correct about the cases they were citing, but they were missing the crucial connection between Rodriguez and Fleming that would clarify the entire jurisdictional question. The morning session deteriorated further as attorneys on both sides struggled with legal precedents that seemed to contradict each other. Judge Brennan called 2 recesses, spent over an hour researching cases in his chambers, and consulted with his law clerk about procedural questions that should have been straightforward. By lunch break, it was clear that the case was headed for mistrial, not because the evidence was insufficient, but because the legal framework was too complex for the current proceedings to handle effectively. During the lunch break, Elena overheard conversations between the attorneys and their research teams. Chen's associates were frantically calling law libraries, trying to verify citations and reconcile contradictory precedents. Holbrook's team was arguing among themselves about litigation strategy, with younger attorneys suggesting approaches that more experienced partners dismissed as legally unsound. Judge Brennan spent his lunch break in chambers, reviewing case law and growing increasingly frustrated with a legal system that seemed to have created a situation where justice was being obscured by procedural complexity. He had handled thousands of cases, but Peterson versus Morrison was testing the limits of his knowledge and experience. When court reconvened at 1:30 p.m., the tension was palpable. Chen had found additional research that she believed supported her argument, but Holbrook had discovered procedural issues that could invalidate her new evidence. Judge Brennan looked like a man who was beginning to question whether the legal system he had served faithfully for decades was capable of producing just outcomes in cases of this complexity. "Ms. Chun," Judge Brennan began, "I've reviewed your additional research during the lunch break. While your interpretation of the Rodriguez decision is creative, I'm not convinced it addresses the jurisdictional issues raised by Mr. Holbrook's constitutional arguments." Chin stood, her voice carrying a note of desperation. "Your Honor, if the court will permit, I believe the key to understanding Rodriguez lies in its relationship to the Fleming decision, which established a framework for federal jurisdiction that—" "Your Honor," Holbrook interrupted, "Fleming versus Consolidated Services was decided by a different circuit court and involved completely different legal issues. Counsel is attempting to create connections between unrelated cases." Judge Brennan rubbed his temples. feeling the weight of decision that would affect not just the immediate parties, but employment law nationwide. Mr. Holbrook, while your objection is noted, I'm not convinced that Fleming is entirely irrelevant. However, I'm also not certain how the two cases relate to each other in the context of current federal employment regulations. The courtroom fell into uncomfortable silence as both legal teams realized they were approaching the limits of their expertise. Chin shuffled through her papers, looking for arguments she might have missed. Holbrook conferred quietly with his associates, searching for procedural motions that could delay proceedings until more research could be completed. Elena, meanwhile, had moved to the front of the courtroom, quietly dusting the jury box that wouldn't be used in this bench trial. She had listened to 6 hours of legal argument, watched brilliant attorneys struggle with concepts that should have been clear, and observed a respected judge wrestle with questions that had straightforward answers, if you knew where to look. The silence stretched on until Judge Brennan finally spoke. I'm going to call a recess until tomorrow morning. This case involves legal complexities that require additional research and consideration. Both counselors will have overnight to... Excuse me. The voice was quiet but clear, carrying easily across the silent courtroom. Every head turned toward the source of the interruption, Elena Martinez, standing near the jury box with a dust cloth in her hand, looking directly at Judge Brennan with the steady gaze of someone who had something important to say. Ma'am, Judge Brennan said gently, this is an active legal proceeding. I'll need to ask you to... Your Honor, Elena interrupted, her voice growing stronger. With respect, Rodriguez versus Universal Manufacturing was not overturned by Fleming versus Consolidated Services. Fleming cited Rodriguez approvingly, but narrowed its application to cases involving interstate commerce, which is exactly what Peterson versus Morrison Industries involves. The courtroom erupted in shocked murmurs. Holbrook jumped to his feet. Your Honor, this is completely inappropriate. Court personnel cannot offer legal opinions during active proceedings. But Judge Brennan raised his hand for silence, his eyes fixed on Elena. Something in her tone, in the precise way she had cited the cases, in the confidence with which she had addressed the central legal issue, suggested that this interruption might not be as inappropriate as it initially appeared. Ma'am, Judge Brennan said carefully, I appreciate your interest in proceedings, but legal arguments must come from licensed attorneys representing the parties to the case. Elena set down her dust cloth and stood straighter, the invisible courthouse employee suddenly commanding the attention of everyone in the room. Your Honor, I am a licensed attorney. California Bar number 47291. Admitted to practice in 1978. I've been listening to this case for 18 months, and I've watched brilliant lawyers struggle with a legal framework that becomes clear when you understand the relationship between federal employment regulations and interstate commerce clause jurisprudence. The silence that followed was absolute. Chin stared at Elena with an expression of complete bewilderment. Holbrook's mouth hung open. Judge Brennan leaned forward in his chair, studying the woman who had just claimed 45 years of legal experience while pushing a cleaning cart through his courtroom. Ma'am, did you just claim to be a practicing attorney? Retired attorney, Elena corrected. I served 22 years as a Superior Court judge in Los Angeles County, specializing in employment and civil rights law. Before that, I was an employment attorney for 18 years. I've been cleaning this courthouse for 3 years because I needed the health insurance and because staying connected to the legal system helps me feel like I'm still contributing something useful. The revelation hit the courtroom like an earthquake. Judge Brennan stared at Elena, processing the implications of what she had just said. Chin sat down heavily in her chair, understanding suddenly why the cleaning lady had seemed unusually interested in their legal arguments. Holbrook began furiously whispering with his associates, trying to determine if Elena's unexpected expertise posed a threat to their litigation strategy. Ma'am, Your Honor, Judge Brennan said, correcting himself as he began to understand who he was addressing. Are you saying that you've been observing these proceedings in your capacity as a former judge? No, Your Honor. I've been cleaning this courtroom in my capacity as a courthouse employee. But I've been listening to the legal arguments because I can't help myself. After 40 years in law, you don't just stop caring about justice because you change jobs. Elena moved closer to the judge's bench, her demeanor shifting from courthouse employee to legal professional. If I may, Your Honor, the central issue in Peterson versus Morrison isn't nearly as complex as it appears. The confusion arises because both counselors are treating Rodriguez and Fleming as conflicting decisions when they actually represent a logical evolution of federal employment law jurisprudence. Judge Brennan glanced at the attorneys, then back at Elena. Please continue. Rodriguez versus Universal Manufacturing established that federal employment regulations supersede state contract law in cases involving interstate commerce. Fleming versus Consolidated Services didn't overturn Rodriguez. It clarified the definition of interstate commerce to include employment relationships that affect commerce between states, even if the actual work performed within a single state. Chen leaned forward, beginning to understand the connection she had been missing. So Morrison Industries' multi-state operations would qualify as interstate commerce under the Fleming definition? Exactly, Elena replied. Morrison Industries operates in 17 states. Their employment practices affect interstate commerce by definition, which brings their employment contracts under federal jurisdiction, according to both Rodriguez and Fleming. Holbrook stood up, his objection ready, but Elena continued before he could speak. Mr. Holbrook's constitutional arguments about Commerce Clause limitations are based on pre-Fleming jurisprudence. The Fifth Circuit's decision in Fleming specifically addressed those constitutional concerns and held that federal employment regulations represent a legitimate exercise of congressional authority under the Commerce Clause. Judge Brennan found himself taking notes for the first time in years, not because he didn't understand the legal concepts, but because Elena's explanation was clarifying issues that had seemed impossibly complex just moments earlier. And the jurisdictional questions that have been consuming so much of our time, resolved by understanding that Rodriguez and Fleming work together, not against each other. Federal jurisdiction applies to Morrison Industries because they engage in interstate commerce. Federal employment regulations supersede their state law employment contracts because Fleming expanded the Rodriguez framework to include exactly this type of business operation. The courtroom had grown completely silent as Elena methodically dismantled the legal confusion that had paralyzed the case for months. Chun and Holbrook were both taking notes, realizing that their research teams had missed the crucial connections that Elena was making seem obvious. Furthermore, Elena continued, the constitutional issues Mr. Holbrook has raised are addressed directly in Fleming at pages 847 to 851, where the Fifth Circuit held that federal employment regulations represent a valid exercise of congressional authority and do not violate state sovereignty principles under the 10th Amendment. Holbrook sat down, recognizing that his constitutional arguments had just been systematically dismantled by someone whose understanding of employment law apparently exceeded his own. Judge Brennan looked at Elena with newfound respect. Your Honor, Ms. Martinez, your analysis appears to resolve the central legal issues that have been troubling this court. But I have to ask, why didn't you speak up earlier? We've been struggling with these questions for months. Elena smiled for the first time since she had begun speaking. Your Honor, I'm a courthouse employee. It's not my place to interrupt legal proceedings, and it's not appropriate for former judges to interfere with active cases. But when I heard you considering a mistrial because of legal complexity that could be resolved with proper research and analysis, I felt I had an obligation to speak. Chun raised her hand tentatively. Your Honor, if I may, Ms. Martinez's analysis seems sound, but I need to ask, how we proceed from here? She's not representing either party, and her legal opinions, while apparently expert, don't have formal standing in the proceedings. Judge Brennan considered this question, recognizing that Elena's intervention had created both an opportunity and a procedural challenge. Ms. Martinez, would you be willing to serve as a court-appointed expert witness on the jurisdictional and constitutional issues? Your analysis could help resolve the legal questions that have been troubling this case. Elena was quiet for a moment, considering the implications of officially re-entering the legal profession, even temporarily. Your Honor, I would be honored to assist the court in any capacity that serve the interests of justice. The transformation of Elena Martinez from invisible courthouse employee to respected legal expert created ripples that extended far beyond courtroom 4. Within hours, word spread throughout the legal community that a retired Superior Court judge had been working as a cleaning lady while observing one of the most complex employment law cases in recent memory. The story reached the Los Angeles Times legal reporter by evening, and by the next morning, Elena's unexpected intervention had become a symbol of dedication to justice that transcended job titles and professional status. Legal blogs picked up the story. Bar associations began discussing the implications of retired judges working in courthouse support positions. And law schools started using the Peterson case as an example of how legal expertise could emerge from unexpected sources. But for Elena, the attention was secondary to the satisfaction of seeing a complex legal case receive the analysis it deserved. When court reconvened the next morning, she was dressed not in her gray cleaning uniform, but in professional attire of someone preparing to testify as an expert witness. Judge Brennan called the court to order and addressed the packed courtroom. Before we continue with the Peterson versus Morrison case, I want to acknowledge the unusual circumstances that led to yesterday's revelations. The court has appointed Ms. Elena Martinez as an expert witness on federal employment law and constitutional issues. Ms. Martinez brings 40 years of legal experience to assist in resolving the jurisdictional questions that have complicated these proceedings. Elena took the witness stand with the composure of someone who had spent decades in courtrooms, but from a very different perspective. She didn't approach for direct examination, but her questions were deferential, recognizing that she was addressing someone whose legal expertise exceeded her own. Ms. Martinez, could you please explain your background for court? I received my law degree from UCLA in 1975, practiced employment law until 1980, and served as a Los Angeles County Superior Court judge from 1980 to 2002. I specialize in employment discrimination, civil rights, and constitutional law cases. After retirement, I worked as a legal consultant until 2018, when I took the courthouse position to maintain my connection to the legal system. And during the 18 months you observed the Peterson case, what was your assessment of the central legal issues? Elena turned toward Judge Brennan as she answered, addressing her explanation to the court rather than to the examining attorney. The case presents a straightforward application of established federal employment law, complicated by research that failed to recognize how Rodriguez and Fleming worked together to establish federal jurisdiction over interstate employers. Her testimony continued for 2 hours, methodically addressing every legal issue that had created confusion during the previous 18 months. She cited cases from memory, explained the evolution of federal employment law over 3 decades, and provided analysis that clarified not just the immediate questions in Peterson versus Morrison, but the broader framework for understanding federal jurisdiction in employment cases. Holbrook's cross-examination was respectful but probing, attempting to find weaknesses in Elena's analysis that might preserve his client's position. But Elena's responses demonstrated mastery of employment law that came from decades of applying these principles in actual cases, not just studying them in law libraries. Ms. Martinez, you've testified that Morrison Industries' multi-state operations bring them under federal jurisdiction, but aren't there exceptions for companies whose interstate activities are minimal? Mr. Holbrook, Morrison Industries operates manufacturing facilities in 17 states, employs over 8,000 people across multiple states, and generates revenue from interstate sales. Under any reasonable definition of interstate commerce, they clearly fall within federal jurisdiction. The exceptions you're referring to apply to small businesses with limited interstate connections, not major manufacturing corporations. But doesn't the 10th Amendment limit federal authority over employment relationships that are primarily local in nature? Elena's response demonstrated not just knowledge of constitutional law, but practical experience in applying it. Mr. Holbrook. That argument might have been viable before Fleming versus Consolidated Services, but the Fifth Circuit specifically addressed 10th Amendment concerns and held that federal employment regulations represent a legitimate exercise of congressional authority. Morrison Industries' multi-state operations placed them clearly within the scope of federal jurisdiction. By the time Elena finished her testimony, the legal issues that had seemed impossibly complex were revealed to be straightforward applications of well-established law. Judge Brennan thanked her for her expert assistance and dismissed her from the witness stand, but Elena's impact on the case was definitive. In his final ruling, Judge Brennan noted that the Peterson case demonstrated both the complexity of modern employment law and the value of experience in navigating that complexity. He ruled in favor of Peterson, finding that Morrison Industries had violated federal employment regulations and that their state law employment contracts could not supersede federal protections. But more importantly, Judge Brennan's written decision included a footnote that will be quoted in legal textbooks for years to come. This court notes that justice was served not just through the adversarial process, but through the unexpected contribution of a retired colleague whose dedication to the law extended beyond official position or professional status. The legal profession is strengthened when experience and wisdom are valued regardless of current employment circumstances. The aftermath of Elena's intervention extended far beyond the Peterson case. Bar associations began reviewing policies about retired judges. Courthouse administrators started recognizing the expertise that might exist among support staff, and law schools began teaching the Peterson case as an example of how legal knowledge could emerge from unexpected sources. Elena returned to her cleaning duties, but with a fundamental change in how she was perceived by the legal professionals who worked in courtroom for. Attorneys began greeting her respectfully. Court staff sought her opinions on procedural questions, and Judge Brennan occasionally consulted with her about complex legal issues that arose in subsequent cases. The story reached national legal publications, and Elena received job offers from law firms, consulting companies, and academic institutions. But she declined them all, explaining that her courthouse position allowed her to stay connected to the legal system while providing the health insurance she needed and the satisfaction of contributing to justice in a different way. 6 months later, the Riverside County Court system created a new position, Senior Legal Advisor, a role that allowed retired judges and experienced attorneys to provide expertise while working in courthouse support positions. Elena became the first person appointed to the position, formally recognizing that legal knowledge and dedication to justice couldn't be measured by job titles or professional status. The Peterson versus Morrison case became required reading in employment law courses, not just for its legal holdings, but for what it demonstrated about expertise, humility, and service. Elena's intervention showed that some of the most important contributions to justice came from people who worked quietly, observed carefully, and spoke only when their knowledge could serve the greater good. Years later, when law students studied the Peterson case, they learned about jurisdictional issues and federal employment law. But they also learned about Elena Martinez, the retired judge who mopped floors and emptied trash cans while maintaining her commitment to justice. And it reminded the legal profession that wisdom and experience were valuable regardless of the uniform someone wore to work. Elena continued cleaning courtroom for 2 more years before fully retiring, but her legacy extended far beyond the cases she observed or the legal questions she helped resolve. She had demonstrated that dedication to justice transcended professional status, that expertise could be found in unexpected places, and that sometimes the most important voice in a courtroom belonged to someone whose contribution had been overlooked until the moment when knowledge and courage combined to serve the cause of justice. The cleaning cart still sits in the corner of courtroom 4, but courthouse employees and legal professionals alike remember the day when it was set aside by someone who proved that legends don't always announce themselves, and that true service to justice can take many forms, all of them valuable, all of them worthy of respect. Some heroes work in robes and make decisions from elevated benches. Others work in gray uniforms and make contributions that are noticed only when expertise becomes essential. Elena Martinez was both, and her story reminds us that the most important qualifications can't always be measured by the credentials on someone's wall or the title on someone's business card. In a profession that sometimes values appearance over substance, Elena's intervention in Peterson versus Morrison stands as a reminder that justice is served best when knowledge, experience, and dedication are valued regardless of their source. And sometimes the person who can solve the most complex legal problems is the one who has been quietly listening, learning, and waiting for the moment when their voice can make the difference between confusion and clarity, between procedural deadlock and substantive justice.